All right, and good morning. I'm Jessica Martin, and I'm an attorney with the New Mexico Immigrant Law Center. The New Mexico Immigrant Law Center is a nonprofit organization that serves immigrant residents here in New Mexico. We provide free immigration legal services to low-income immigrants here in New Mexico. What we're going to talk about today is supporting immigrant and refugee status adolescents. And the subtitle I've come up with for this presentation is Finding Relief to Overcome Barriers. So I want to kind of frame how we're going to approach the topic today. And we're not going to talk about social barriers. We're not going to talk about how isolated immigrant families are. We're not going to talk about language barriers. Today we're really just going to focus on the law. So we're going to talk about public benefits, Medicaid, access to health care, and access to higher education, and what the legal barriers are for immigrants of varying statuses to access these benefits. And then the finding relief portion is we're actually going to go over some common forms of immigration relief eligible that many children are eligible for that would increase their access to these benefits. So increasing access to health care, to public benefits, and to higher education so we can achieve better outcomes for immigrant youth in our state. So I want to start, I guess I moved the slide forward, huh? Okay. So let's start with, I want you to think about in your practice, what barriers have adolescents without immigration status faced accessing either health care, public benefits, or education. And I want you to think about a particular youth situation and just take a minute to jot that down. We'll be referring throughout, and I'll have you think back on this situation to apply some of what we're learning. For those of you who have not had much experience working with immigrant adolescents, Rachel Chandler, PA, who's here today in our audience in Albuquerque, has given us a scenario that we can use throughout too. So if you haven't had an experience with immigrant youth yet, don't worry. I'll provide you with a little hypo as we go through. All right, and so the second thing I want you to kind of think about as we go through, in your work with adolescents, have you ever wondered what possible legal status they could gain? What are different types of legal immigration status, and how would children qualify to improve their access to different programs? And we will be going over, as I said, several of those types of immigration status and what the basic requirements are. So just have those in mind as we go through. All right, I think it's always important to start with different types of immigration status and really understanding what it means to be without status, and then there are pages and pages of different types of immigration status. We'll just cover a few, but I've broken them down into categories that will help guide us in our discussion today. So first are those that have the least rights and the least amount of access to benefits programs, and those are who are without status or undocumented. So these may be people who come in with a visitor's visa or with a border crossing card, but who overstayed their authorized time here. Authorized time, maximums usually up to 6 months. So if you have an immigrant that you're working with who has a visa that says it's good for 10 years, if they've been here more than 6 months, they're probably without status at this point. So they would be in that undocumented category. They're only considered in kind of active authorized status if they're compliant with the terms of that visa. Going down from there, we have, or actually, I should have done this in reverse, going up from there, getting slightly more protection, slightly more rights, a little bit more access to benefits programs. We have deferred action. Deferred action is not actually a legal status. It's a determination by the Department of Homeland Security that someone is a low priority for removal from the United States. In some ways it's a protection against deportation, and usually a person with deferred action is eligible for a work permit. And once you get a work permit, you can apply for a Social Security number. That does not mean that that Social Security number is going to open all the doors to benefits programs for you. You still don't have legal status, but it does make access to some benefits easier. From there, we have lawful status. So these are people who have a lawful immigration status here in the United States, and that can be lawful permanent residence. It's a permanent status. It's also, some of you may be familiar with it more as a green card holder. So someone who has a green card, who has permanent residence here, it's the next best thing to U.S. citizenship. Once you're a lawful permanent resident, after a certain number of years, you can apply to become a U.S. citizen. Other types of lawful status are asylees, refugees, other types of temporary statuses such as U status or T status. U status is for crime victims who've assisted in investigations or prosecutions of crime. T visas are for trafficking victims. So you can see here there's a myriad of different lawful immigration statuses. And so figuring out who's eligible for what benefits programs is very complicated. And we do have a chart that we'll refer to later to see some of the variations. Finally, the highest status that an immigrant in the United States can attain is that of a U.S. citizen. It's through a process called naturalization. And a naturalized U.S. citizen shares all the rights that a U.S. citizen born in the United States would share, including the right to vote, access to Social Security benefits, and a myriad other benefits. The only reason that a naturalized U.S. citizen could run into problems is if there was some fraud in their immigration process that immigration became aware of. But otherwise, once they're a naturalized U.S. citizen, it's not something that can be taken away.
I have a question. At which level of status is a person eligible to serve in the armed forces?
So there's some confusion about that. My general understanding is that you have to be a lawful permanent resident to enter the armed forces. But with that said, recruiters do not ask for the same documentation when they're enlisting people. And I've had many of my clients come to me that say, my recruiter said that all I need is a Social Security number. So if I get deferred action and I get that work permit, I can get that social, and then I can join the armed forces. So by regulation, probably that's not accurate. But recruiters in the armed forces are doing what they're doing. But my understanding is you have to be a lawful permanent resident to enter the armed forces. Some of these areas are going to get outside of my expertise, and I will let you know when I am making an educated guess and when I am when it's something I'm knowledgeable about. So that is something that is an educated guess on my part based on my experience, but I have not actually read the law on that particular question. All right, so eligibility for public benefits. These are just some general rules. So generally, undocumented immigrants are not eligible for public benefits, including Medicaid. There are some exceptions. Undocumented immigrant children are eligible for WIC. Undocumented immigrants are eligible for EMSA, and then undocumented immigrant children are eligible for school and summer meal programs. Immigrants in qualified status are eligible for most benefits programs, and this includes refugees, asylees, and certain battered women and children. And again, the qualified immigrant status is defined by federal law and constitutes several pages of federal regulations. So again, very complicated. The New Mexico Center on Law and Poverty has done a fabulous chart for immigrant access to public benefits here in New Mexico. And the chart does separate out different types of immigration status and in New Mexico what types of public benefits they would be eligible for. And that's included in the resources that you can download. So after this presentation, you should have enough knowledge to be able to look at that chart and be able to read the basics of it, see what status your patients or clients might be in, and what they might be eligible for. There's also an attorney on staff at the New Mexico Center on Law and Poverty who will, in certain cases, represent clients who have been wrongly denied benefits. And so that's a resource you can go to ask further questions about eligibility, and also if you have someone who's just repeatedly denied, who after discussion with the experts at CLP have determined they are eligible, but Human Services, Health and Human Services has not recognized their eligibility. Finally, we have lawful permanent residents, LPRs for short, who are eligible for all benefits programs, but some programs require a 5-year wait. So if I were to become a permanent resident tomorrow, for some programs, I would have to wait 5 years before I became eligible. And one of your handouts, one of the other documents you can download, I actually believe it's the first page of that same chart put out by New Mexico Center on Law and Poverty, describes more the restrictions on certain programs, which programs have the 5-year restrictions and which do not. So as you can see, this is a very large area of law, and we are just covering the very basics today, but I'm hoping that I can give you resources that you can start to investigate more on your own. And it may produce more questions than answers initially, but I hope by the end of this you have the resources on who you can ask with your additional questions. So other eligibility, the Affordable Care Act. Unfortunately, the Affordable Care Act has excluded undocumented immigrants from participation in exchange programs, and has also excluded what we call documented immigrants. So these are young people who have been granted deferred action status based on the Deferred Action for Childhood Arrivals program. So this was Obama's initiative in 2012 to help young people who'd come to the United States before they were 16 years old and who've been continuously present since June 15, 2007 till now, to help them get a protection from deportation and a work permit. It coincided around the time of the Affordable Care Act, and so immediately they were excluded from participating in exchange programs. So that's unfortunate. Supplemental security income. This is an area that is outside of my knowledge, but from my basic understanding and the materials that I've read, U.S. citizens are, of course, eligible for SSI. Some qualified immigrants are eligible, such as asylees and refugees, and some lawful permanent residents are, but subject to additional requirements, such as have you completed 40 quarters of employment in the United States to become eligible for SSI. And that's just one. There are many other permutations. But for those of you who are working with clients with disabilities, also the New Mexico Center on Law and Poverty has a 75-page manual on access to public benefits for immigrants, and in that manual is a section on SSI. So what about higher education? In some states, undocumented immigrants are prohibited from enrolling in state public colleges and universities, completely in Alabama and South Carolina, and partially in Georgia. The partial restriction in Georgia has to do with educational need of those who have immigration status and who are U.S. citizens, And from my research, it looked like about 80 to 90% of the public institutions prohibited enrollment there. So the ban was pretty extensive in Georgia also. So that's the downside. 20 states provide in-state tuition for undocumented immigrants, including New Mexico, but there are other requirements. For example, some states require that the student have attended 3 years of high school in that state and graduated high school in that state in order to get in-state tuition. There is also one of the resources you can download has more information in a chart state by state as to eligibility requirements. There are 5 states that, in addition to providing in-state tuition, also provide state financial assistance, and New Mexico is one of those. I wanted to take a minute to look at the actual law so that you can see the language of which students would qualify for in-state tuition. So this was, I think it's SB 560. And this is now codified in our statutes. But if you scroll down to the bottom half of the document, so yeah, SB 582. So if you look at that there, first of all, there's a great non-discriminatory clause, but there's also the requirement that any undocumented student, though they have equal rights to other students, they have to have completed at least 1 year of high school in New Mexico and graduated from a New Mexico high school or received their GED in New Mexico. So when you have patients or clients who are moving from other states, who may be 19 or 20 years old, they may face certain barriers in getting in-state tuition and state financial aid. But someone who has completed at least 1 year of high school, regardless of their immigration status, if they've graduated from a New Mexico high school and attended 1 year here in New Mexico or have their GED here, in addition to attending the 1 year of school here, that should be sufficient for them to get those benefits.
So they can't just like come here and get a GED retrospectively. They have to have the 1 year as well.
They have to have the 1 year as well. So they should probably enroll in an alternative high school that prepares them for a GED program. Yes. Okay. All right. So lastly, when we're thinking about federal financial aid, U.S. citizens and permanent residents qualify for federal financial aid, as do some qualified aliens. And qualified aliens is actually what it says in the federal regulation. We prefer to call them qualified immigrants. But again, it's pages and pages to determine who is a qualified immigrant for federal financial aid purposes. And I'll discuss some of those when we go through different types of relief for youth. But it is a complex area. Okay, so I want you to think about the individual that you wrote about when we started our discussion. And I want you to look at these questions. I would say these are the top 5 questions I think that you should ask any immigrant adolescent that you're working with. Ask the adolescent and ask the child's parents, guardians, or caretakers, because these are key questions to determining if the child might be eligible for some form of relief. So does the child have a parent with lawful status? Does the child live apart from one or both parents? And if so, is it due to abandonment, neglect, or abuse? Abandonment is pretty straightforward. If the parent's not here, not present, isn't providing financial support, that's abandonment. So this could be very broad. This could be a single family household where the non-custodial parent is not in the picture, not really complying with their duties as a parent. Is the child or the child's parent a victim of domestic violence? If so, by whom? Has the child or the child's parent or sibling been a victim of a crime in the United States? Has the child been present in the U.S. continuously since June 15, 2007, or if not, since January 1st, 2010? And these all relate to different types of immigration status that we'll review shortly. But in your mind, think about that individual you wrote about and think about if you know the answer to any of these questions off the top of your head. And if you don't, which questions would you want to ask your individual? Rachel had brought up in the beginning, before we went on camera, one of the patients she'd been working with was an undocumented teen who was pregnant. And so what were her access? Could she access different healthcare options? Could she access Medicaid? And so when we go through the different types of relief, we'll actually kind of bring up Rachel's hypo as we go through to think about which of these types of status might enable her to access Medicaid and the health care that she needs, the prenatal care that she needs.
Yeah, how broad is the victim of a crime?
So the victim of the crime, we're going to go through that shortly with the U visa, but the victim of the crime has to be a specific crime enumerated in the U visa law. But if you think about it in broad terms of crimes of violence or crimes of exploitation, that usually will cover that category. And they don't always need to be felony crimes. It could be misdemeanor domestic violence, other types of, false imprisonment. There are many different types of crimes that could qualify, but generally, if you think about it in terms of violent crimes or crimes of exploitation, that'll get you in the right ballpark. If it's someone steals your car out of your driveway and there's no threat to you during the process, that's probably not going to qualify. Armed robberies. I've had clients who've been at ATMs and held at gunpoint at the ATM. That, of course, violent crime, something like that would qualify. Okay, so we're going to talk about some different paths to legal status. And the first that we're going to talk about is actually the area that I find least accessible for children. It's basic family immigration. And a child, parents who have status can petition for their children who do not have status. So a lawful permanent resident or U.S. citizen parent can petition for their immigrant child to become a lawful permanent resident. A child is defined in immigration law as anyone under age 21 who is unmarried. So that's actually a little broader than some of us might think. So a 20-year-old in immigration law is still a child as long as they're unmarried. The process, the barriers, unfortunately, are that it's very high cost. The initial application is about $500. The application for permanent residency is $1,070. Those are just the fees that immigration charges. If the person needs any kind of legal representation, if they have any complexities in their case, that's thousands of dollars more. So if you have a low-income family, perhaps dad is a permanent resident and has 4 undocumented children, tens of thousands of dollars potentially to immigrate his children. So this is why we see a lot of youth who are still undocumented, although they have a parent with legal status. But there are certain circumstances in which children do actually become lawful permanent residents through their parents. And once they're lawful permanent residents, if they've been in lawful permanent resident status for 5 years and they're at least 18, they can apply to become citizens. So this is a pathway to citizenship, and it's a good option for some. There are many bars for certain offenses under immigration law that would prevent someone or make the case very complicated. So for example, a child who's entered without inspection, so without documents, several times in their childhood, would be barred from immigrating through a parent under basic family immigration. So when you think about, we're a border state, a lot of our families have come and grown across that border many times. So I find this generally is not the most accessible option for low-income, vulnerable families that we're working with in New Mexico. Another potential path to legal status, which is very broad and which I think is the most, if you retain anything from today's presentation, this is the slide I'd like for you to retain. Special immigrant juvenile status is also a pathway to lawful permanent residence and citizenship for children. To qualify, a state court has to find that the child's reunification with one or both parents is not possible due to abuse, neglect, or abandonment. And as I mentioned on an earlier slide, neglect and abandonment are very broad. So when we think about that single parent household where the non-custodial parent maybe isn't paying child support, maybe hasn't even been in touch in a year, isn't making any educational decisions, isn't making any medical decisions for the child. All of these things could constitute neglect or abandonment. So this is a very broad form of relief. The state court, in addition to determining that reunification with one of the parents isn't viable, has to determine that it's not in the best interest of the child to return to their country. And that's usually a very easy determination to make if other family members are here, if the child hasn't been in their country of origin for many years. So special immigrant juvenile status is unique in that it's a hybrid form of relief that requires an order from a state court with specific findings under New Mexico law before the child can even apply with immigration for this status. So in my office, a lot of our clients are pursuing kinship guardianships. Parents are pursuing sole custody orders with these findings so that their child can then pursue special immigrant juvenile status. There are many different vehicles in state court that could get the child this predicate order that they need to apply for SIJS. Some of the benefits for SIJS, immediate eligibility for Medicaid. The minute that application for SIJS is filed with U.S. Citizenship and Immigration Services, that child under New Mexico law becomes eligible for Medicaid. In addition, SIJS is a very fast road to lawful permanent residence, sometimes as quick as 6 months, and many of those 5-year waiting periods do not apply. So the child may also become very quickly eligible for public benefits, federal financial aid, for higher education. So special immigrant juvenile status is very broad, legally somewhat complicated, definitely would need an immigration attorney and probably a family law attorney as well for the process, but the benefits are huge. The process also has fee waivers available, so it could potentially cost the child nothing to apply. And it is one of the services that our office provides free. So this is a very accessible possibility for low-income families in New Mexico. Potential path to legal status, VAWA, the Violence Against Women Act. This is for certain children or spouses who've been battered or subject to extreme cruelty, so who've gone through, we can generally think of it as domestic violence, who've experienced domestic violence. Catch here is that the abuser has to have a legal relationship, in other words, be the biological parent or step parent of the child or the legal spouse of the child's parent. So if the couple's married, but they both lack immigration status, VAWA is not going to be an option. The abuser, who's either the parent or the spouse, has to have legal status as a permanent resident or a U.S. citizen.
Oh.
So
Oh, I was
Just
just
take a
sending you a
minute here.
text to say that it depends on the details on whether I can get off to go. And I would be happy
Could
to
I
go
ask
on,
a
but I
really
don't have the
obvious
number.
question? Is this just for female children?
no, this
Oh,
is
okay.
for, it could be male or female spouses or male or female children. Yeah, we've had men who've experienced domestic violence with female partners. When you think about the inequities of someone who has legal status and someone who doesn't, it creates a power dynamic right there. And so undocumented males are more likely to experience domestic violence in their relationship than a male with status.
So when you're ready for it.
Okay, so VAWA grants deferred action, so that's that protection against deportation and a work permit. It also is a pathway to permanent residence and citizenship. And someone who is approved under VAWA is in qualified immigrant status for public benefits and federal financial aid. So this is one of those unique types of relief where even though they're just granted deferred action, still have great access to public benefits and federal financial aid as with their status as battered immigrant spouses or children. All of these things I'm going over, I'm giving you the very basics. One of the downloads that you have, one of the resources you have accessible to you is a publication by the Immigrant Legal Resource Center, the ILRC, Immigration Options for Undocumented Immigrant Children. And that has one-page fact sheets on a number of different types of relief, including all of the ones we're discussing today. So it goes into all of the legal requirements. Okay, another type of relief, a U visa. Someone could qualify for a U visa if they've been the victim of a designated crime, if they've suffered substantial physical or mental abuse as a result of that crime, and if they've assisted or are likely to assist in the investigation or prosecution of the crime. So this is also very broad, and unfortunately in New Mexico, we have a very high crime rate and very high, it's disturbing sometimes when we're doing consultations and intakes how many families have been victims of violent crimes in the United States. And so this is another question that I would recommend that you always ask. Have you or has someone in your family been the victim of a crime that was reported to police? Immediate family members can be included. So, for example, perhaps it's not the child that was the victim of the crime. Perhaps it was a parent. Maybe mom was a victim of domestic violence. Mom could include her children under the age of 21 who are unmarried on her application. So again, that's why it's important not just to talk to the adolescents you're working with, but when possible, their parents, to see about possible forms of immigration relief. So the U visa is a very long process, and the person ends up going through various types of status, but it is a road to permanent residence and citizenship. Those with U status are eligible under the Affordable Care Act, and if they're under 21 or pregnant, may also be eligible for Medicaid. So having U status opens up possibilities. Deferred action for childhood arrivals, DACA for short, and we're going to call it DACA 2012. It's a policy, not law, that allows certain young people to request protection against deportation here in the United States for a 2-year period and to gain a work permit. President Obama announced this executive action in June of 2012. In November of 2014, he announced expansions to the DACA program and a new deferred action program for parents, but unfortunately, those newer executive action programs are caught up in lawsuits and are not in place at this time. The Supreme Court has agreed to hear the case, and we're expecting a decision in June. But right now, all we have is DACA 2012. The basic eligibility requirements are listed on the slide. The child has to be at least 15 unless they've been previously removed or are in removal proceedings. So the adolescent you're working with has been deported before. It may not matter whether they're 15 or not. They may be eligible earlier. The person has to have been born after June 15, 1981. So this is a remedy that is for young people. Someone who was born in 1980 would not be eligible under DACA 2012. The expanded program that's now caught up in lawsuits would remove that age cap. The person has to have lived in the United States prior to their 16th birthday, resided here continuously since June 15, 2007, be currently in school or already have a high school diploma or GED, and certain criminal convictions will disqualify an individual for eligibility for DACA. The benefits of DACA. So some of the kind of soft benefits are it's an incentive for undocumented youth to stay in school, right? If you're 16 and you drop out, you're not in school, you don't have your GED, you don't have your diploma, you're not eligible for DACA. So stay in school, you can be eligible for DACA, get your work permit. Also, now that you have your work permit and your Social Security number, you may now be eligible for certain professional licenses. This is often an incentive for youth with DACA to pursue higher education. Before, perhaps they weren't going to be able to get a license to be a nurse or a license to be an attorney. But with DACA, with their employment authorization and Social Security number, those are possibilities. Drawbacks of DACA, not eligible for public benefits, not eligible for federal financial aid, not eligible for the exchange under Affordable Care Act. So in most ways, the youth has no more benefits than an undocumented child. So instead, I like to kind of see it as more of these soft benefits to encourage youth to stay in school and to pursue higher education. And to have access to lawful employment, which of course improves someone's condition significantly. These are just another few types of status I want you to have in mind. T visas for victims of trafficking. Parole is something that the Department of Homeland Security might grant when someone first enters the United States for humanitarian purposes. And the only reason I bring it up here is because for whatever reason, someone who's been paroled for at least 1 year is eligible for a large amount of public benefits. So this is someone who doesn't have legal status, who just got here, kind of goes against all of our other general rules that we've talked about. But in fact, parolees who they have a little square piece of white paper that says paroled, that's all it is. But if it's for at least 1 year, would qualify for many benefits programs. So it's another important question to ask. And usually you can ask, do you have a little white piece of paper from when you came in? Asylees, to be granted asylum, you have to apply from within the United States and show fear of persecution in your home country. Refugees, you have to be granted status outside the United States and also show that same fear of persecution. And then my partial thought at the bottom, which I did not finish, refugees who do not become U.S. citizen within 7 years will lose access to benefits programs. So it's very important when you're working with refugee families, and I think the next slide is on refugees, yes, that you encourage them as soon as they're eligible to apply for citizenship that they do so. So when a person enters the United States as a refugee, they're in refugee status for 1 year, and then they apply for permanent resident status. We've talked about permanent resident status being that next best status to becoming a U.S. citizen. So very stable status, access to most benefits programs. After 5 years in permanent resident status, a refugee who's over 18 can apply to naturalize to become a U.S. citizen. And any refugee children of that person who becomes a U.S. citizen, naturalizes to become a U.S. citizen, automatically derives U.S. citizenship. So again, when you're working with adolescents who have had refugee status and are now permanent residents, perhaps it's someone with disabilities, perhaps you're having certain barriers to certain benefits programs, encourage parents to apply for U.S. citizenship as soon as they're eligible, because that can have immediate impacts for their children under 18. All right. So I'd like to move this presentation more to discussion now. I want you to remember the youth that you wrote about earlier. What questions would you ask the youth or parent to determine if there might be options for lawful or more permanent immigration status? So I'm going to back it up to that slide where we had the 5 questions. And Rachel had brought up the hypo about the undocumented teen who is pregnant. So we'd want to find out if parents have lawful status. Is family immigration going to be a possibility? And as we talked about, there's certain barriers with that. Rachel, I don't know if you want to go through the questions and kind of talk through your example for us to think about if you know the answers to any of these questions or what ones you think in this child's or this adolescent's case might be particularly applicable.
Sure. So I will say with this adolescent, it was a little difficult, and of course I didn't know to ask many of these questions, but she was also being seen for a confidential visit. Mm-hmm. So it wasn't one where speaking with the parent or including the parent in discussing these kinds of topics was an option at this point. And so for question number 1, the child did not think that their parent had lawful status. She wasn't entirely sure what kind of status her mother had, but she didn't believe that it was lawful status. And she did only live with her mother, and I didn't quite get the full story of what was going on with the dad or anything. When I did see her, we didn't get to spend too much time on all of these questions because there was a lot of counseling that had to be done regarding the pregnancy and her pregnancy options. And then for the next 3 questions, 3 through 5, I did not know the answers to those questions, but they would be good ones to ask.
So let's jump to number 2, okay? Because this gets to that question. I said if you take away anything from this presentation today, I want you to take away special immigrant juvenile status, okay? So Rachel told me that this particular teen was 18, right? It sounds like she's just living with her mom. We don't know what the circumstances with dad are. But there's a possibility that maybe mom already has sole legal and physical custody of her daughter. Or it could be a possibility that she could pursue it. Under New Mexico law, and I think you had told me in the beginning too, she was still in school. She was still in high school. So under New Mexico law, someone can file for custody of their children up to the age of 18, or beyond that if the child is still attending high school. So for this particular teen, I would definitely ask questions about special immigrant juvenile status and see if this might be an option. And as we were saying, immediately upon filing, she would become eligible for Medicaid. She could get the prenatal care she needs. The immigration process might take longer than the prenatal process, but then at least she would have care after her pregnancy. She would have access to public benefits, not only for her U.S. citizen-born child, but for herself. So definitely these would be good questions to ask. And I think Rachel brings up a great point, too. Your primary role is to provide health care, other services to children and adolescents. In your 10 or 15-minute appointment, you have how many other people waiting for you? How much time do you have to ask legal questions about immigration? Maybe not too much, but when you think about all of the benefits that it could bring, and it might save you the 10,000 phone calls to all the different programs trying to get them connected with some service that might provide prenatal care. Just take a couple minutes to ask the 5 questions that we went over, and I think for your case this would be key.
Yeah. Can I ask a question? So
Yeah.
For them to apply for the special immigrant juvenile status, do they have to have a parent who has legal custody of them?
So
Is that what you're saying?
So they would have to get a state court order with these findings of abuse, neglect, or abandonment, and so there's a number of vehicles to get into state court to get this, and so mom may have to petition for sole custody of her child if she didn't have it already. If she already had it, it might just be a motion to modify that custody agreement to add these findings, so the child could become eligible for SIJS. Yeah. Did anyone else have an individual that they had thought about and who, for them, one of these questions kind of jumped out as something they might want to ask?
So I have a question about the education piece. So if the child and family have not gone through these processes, but in New Mexico the child was eligible for higher education, went to higher education, is now in graduate school, if they haven't changed their status, what does that mean for them working after they finish?
Right. So this is where we're looking for that potential DACA eligibility. So it would be question 5. Has the child been present in the United States since June 15, 2007? And for DACA, these are all of the other requirements. So we're hoping that they would meet these, because then they could get a work permit and a social security number and could then pursue lawful employment. For undocumented students who do not meet the eligibility requirements for DACA and do not have legal status, it's possible that at some point they may marry someone with legal status and could go through a family immigration process. But again, there are many barriers for immigration offenses, things that you and I wouldn't think of as offenses, but are offenses under immigration law. So if the person is not eligible for DACA and is not eligible for these other forms of relief, there is not the opportunity for lawful employment authorization unless the person can get some kind of entrepreneurial visa, and that is an area of work that is beyond my knowledge. But I was recently at a conference in New York in December, and one of the panel discussions was on how it's in the interest of the United States to change its laws around entrepreneurial visas, because we have so many people who are getting higher education, who are foreign-born, who don't have lawful status here, or maybe came in student visa status, but then once they're not a student, don't have status. And isn't it in the interest of our nation to want to retain these highly educated people for our workforce rather than sending them back to other competing countries and having them enter those workforces? So it's another area for immigration reform, and I'm not familiar with all of the nuances of what types of visas would be available for highly skilled workers and entrepreneurs. And some of the requirements require that the person is outside of the United States, not already present within the United States when they apply for such visas. So it can be very complicated.
So in this case, I do know that these things are true. So this student would have been eligible, but what happens after that? I mean, clearly they're growing up. They're older than 21 now.
Yeah. So they, as long as the DACA program remains in place, they can continue to renew their work permit. Okay. The Democratic candidates have talked about different options. Hillary Clinton spoke at the conference I was at in December, and she had said she would go above and beyond Obama's DACA 2012 program, that she would use her executive powers to take it even further. So, I mean, a lot's going to depend on the election and who becomes president in January 2017, but all of the Democratic candidates had said that they will at least retain DACA 2012, if not try to expand it and push it further. So we hope that the programs are around for longer. Of course, we are all also waiting for immigration reform, but as we've seen in Congress over the last 20 years, there has been a complete inability to pass any kind of immigration reform. DACA is actually based on the proposed DREAM Act, which floated around in Congress for more than a decade, but was geared to exactly this population and would have given them lawful permanent resident status and a pathway to citizenship. And for whatever reason, politics, it never passed. And so that was when President Obama took things in his hands and said, you know what, if Congress isn't going to act, I need to do what's within my power to provide something to immigrant youth in this situation.
Do we have any questions from our audience, either on the phone or via chat? So I thought we had a comment coming in via our chat, and when it comes up, I will read it.
I have a kind of a more of a systems question that you may or may not be able to answer, but you know, the kind of reading in the last few years about different states or different law schools having kind of health justice programs where they are having law students or lawyers be present in physicians' offices. I was thinking when you talked about, you know, does the primary care provider have time to ask these legal questions? Are you aware of any kind of program associated with law school here that would place an intern or a law student in a medical environment?
Yeah, so there is actually a medical legal alliance between the UNM School of Law and UNMH. The Medical Legal Alliance serves the Southeast Heights Clinic and the Young Children's Health Center. Mm-hmm. So in the Southeast Heights part of Albuquerque. And so law students regularly do intakes at those sites and represent patients at those clinics. So it is somewhat limited to those locations. My organization, the New Mexico Immigrant Law Center, we have a partnership model, a community partnership model. We work very closely with other organizations that work with immigrant families. So, for example, Enlace Comunitario that provides domestic violence services. We also partner with schools, with specific high schools that have high immigrant populations, to try to reach out to youth that would be eligible for DACA. And we have had some medical illegal alliances ourselves, connections with Centro Savila, for example. So we have kind of a direct referral system. But other than that, I'm not aware of any kind of wider programs that could place a law student or intern at other sites other than those that have already been designated. But one of my hopes with this presentation is that now you will at least have the contact information for the New Mexico Immigrant Law Center. And we do have phone hours where an attorney answers the phone only 2 hours a week, unfortunately. That's all that we can manage. But anyone can call in and get answers to their immigration questions. So it can be providers, it can be the immigrant, him or herself, who can call. And then also, if you're working at a location that has a very high population of immigrant families that you're serving, definitely get in contact with me. My email information is on the slide. That's the best way to get in touch with me. And we can talk about ways in which we can increase access to legal services. And perhaps kind of smaller trainings are needed on site. We have an AmeriCorps volunteer who does presentations for us. We have a Jesuit volunteer who also is out in the community doing outreach at different sites. Even if it's not one of our attorneys, we do have other staff who's doing outreach in the community who could provide other resources to you at your locations and to your communities that you're working with.
That's great. When you think about the associated, health conditions that are exacerbated by certain kinds of things that need other kind of advocacy besides medical advocacy, substandard housing, for instance.
Oh, yeah.
Those kinds of issues are so common here that
Yeah,
it's a great platform for that kind of work.